Hello, everybody. Welcome back to Betweenity's virtual conference on Africa competition regulation. It is day 3, and it is great to welcome you back. Thank you for your great support for the conference. Today, we have a very interesting discussion. We are going to deal with the topic state control over private assets, the case of Chad and Zambia. And we have an expert panel today consisting of Pieter Steyn, a partner at Werksmans in South Africa, and Chairperson of Lex Africa, an alliance of leading law firms with over 600 lawyers in 30 African countries. Then we have Sydney Chisenga, his managing partner and head of dispute resolution and public policy at Corpus Legal Practitioners in Zambia. He's also the African Liaison Officer of the Antitrust Committee of the International Bar Association. And we also have Mr. Isaac Tausha. He is the Chief Economist of the COMESA Competition Commission in Malawi. Welcome, gents. It is a great privilege to have you on this very important panel today.
Thank you.
We are going to discuss 2 cases today. Two events. The one is a case, the other one is a legislative change that has happened about 2 years ago. The first one is the expropriation of merger assets by the Chadian government in 2023. And the second one is an amendment to the Competition and Consumer Protection Act of Zambia, and that was also towards the end of 2023. We are going to start with a Chadian expropriation event, and I'm just going to provide you with a broad indication of what happened, and then Pieter will take us through that development in depth. In December 2022, Savannah acquired the oil pipeline that runs between Chad and Cameroon from ExxonMobil. And 90% of that pipeline is located in Cameroon, and only 10% is located in Chad. The Cameroonian part of the pipeline is owned and operated by COTCO, which stands for Cameroon Oil Transportation Company. And shortly after the approval of the acquisition on 29 March 2023, the Parliament of Chad approved a bill to nationalize the oil assets that was acquired by Savannah. In other words, that 10% of the pipeline that is on the Chadian side of the border. And according to the Chadian government, the reasons for the nationalization of the assets were that the final terms of the merger were different from what had been presented by the merging parties to the Chadian government, and it transpired that Savannah and the National Hydrocarbons Company, SNH, which is a Cameroonian company, had entered into an additional agreement behind the scenes in terms of which NSH would acquire 10% of the shares from Savannah in COTCO. Previously, Savannah said it would take legal action against the Chadian government for nationalizing the merger assets. I'm aware that there was a Paris Court of Arbitration, but they have rejected a bid by Savannah to freeze COTCO's accounts after that nationalization of assets. But someone who is in a much better position to tell us more about the whole merger and the arbitration is our panelist, Pieter Steyn. So, Pieter, if you can take us through the history of that case based on publicly available documents. Thanks so much.
Thank you very much, Odie. It's good to be on the panel. Thank you for the opportunity. It's quite a long and complicated history, and I think the lessons to be learned from it we can debate after. I've just summarized the fact. You've summarized the basic fact.
Yes.
But I think key things are to remember is that there were agreements between the Chadian government consortium in terms of which there were certain approval requirements. More importantly, there was a requirement that if a consortium member change of control required approval from the Chadian Minister of Petroleum and Energy, there were also preemptive rights in favor of the other consortium members. So I think, the background, I think, is important because those agreements were binding contractual agreements between the consortium and the Chadian government, which regulated the Dorba oil fields and also regulated the operation of the oil pipeline. It's interesting because this is a cross-border deal. I mean, Chad is a landlocked country. To export its oil, and it's got significant oil reserves. The pipeline goes through Cameroon to the port in Cameroon to export it. So it's a key infrastructure project, and bearing in mind that oil infrastructure, oil projects like mining projects require significant amounts of capital expenditure. But as you rightly say, the deal was signed, I think, in December 2021. Savannah, a UK-based company, listed, I think, in London, acquired the shares held by ExxonMobil in Kotco and Totco, Totco being the Chad company, Kotco being the Cameroonian company. And those agreements were subject to conditions, getting the minister's approval, and also dealing with the preemptive rights issues. And the preemptive rights issues, they had to offer the shares to the other consortium members. Other consortium members had 30 days to accept it. And then importantly, and this is one of the arguments the Chadian government raises, the ExxonMobil then had 120 days to complete the sale to Savannah, failing which the preemptive rights knocked in again. So the Exxon and Savannah both liaised with the Chadian authorities. And I've read the ICC arbitral decision in the interim. It wasn't a final decision on the merits, but it was to freeze the bank accounts and dealt with board issues. But it seems quite clear that the Chadian minister did not give approval, and arguably also that the 120 days did expire. But in terms of the agreement between so if it expired, it meant they had to start the preemptive process again, unless the other consortium members waived their rights. So those are the two issues. The starting point in this whole matter, it's a contractual issue.
Yeah.
The agreements were very clear. You need ministerial approval, prior ministerial approval of it. And also, you need to deal with the preemptive process. But in terms of the Exxon-Savannah deal, the long stop date, the date for fulfillment of the conditions was 12 December 2022. And 9 December, Savannah announced they were completing the deal. And it's not, it seems to me, and it seems from the ICC arbitrators panel as well, that there was no formal written ministerial approval. And the issue of the preemptive rights issue is also not, there were no written waivers of preemptive rights by the other consortium. And arguably, the extra 120 days had also expired. So that is, if that expires, then the preemptive rights knock in again, and they've got to wait and now go through the 30 days again. So Savannah announced the completion of the deal. I've read an article where they're apparently relying on tacit consent, which, I mean, I'm a contract lawyer. I don't think that's a terribly strong argument. I'm not a litigator, but I certainly wouldn't advise my client in the context of a written agreement requiring prior approval from a government ministry that they rely on tacit consent, particularly where the correspondence is quite clear. The minister had asked for further information. They'd asked in writing for the process to be suspended. They'd raised questions about Savannah's financial capability. And that's important, bearing in mind it's an oil project which requires significant access to capital. I mean, that's absolutely critical.
Yes. So
Savannah announced the completion of the deal and then went ahead to implement board approval, board changes of the directors of Kotco. And Kotco, the shareholders of Kotco are the consortium, the Chadian government or Chadian entities, and the Camerooni government.
Yeah.
Totco is Chad and the consortium. Interestingly, the Camerooni government does not have a shareholding in Totco. But the Kotco board was changed, and the Chadians opposed and objected to the change in the board of Kotco. The Chadian High Court suspending the transfer of shares to Savannah. And then, the story gets really quite interesting because just before, in February 2023, the Chadian government entities effectively acquired a stake in both Kotco and Totco, which amounted to a majority stake in the consortium, a 59.82% stake in Totco, and a 53.77% stake in Kotco. And that triggered a notification to the CMAC Competition Authority. the regional competition authority. And that notification was approved quite quickly in May 2023, but the CMAC authority approved it subject to certain commitments relating to the composition of the board of COTCO, as well as a potential transfer of shares in COTCO to the Cameroonian government entity. But the further interesting thing is in March 2023, so February 2023, Chad acquires a majority stake in both companies, which was obviously concerning to the Cameroonian authorities. But then in March 2023, as you said, they nationalized the assets, the shares held by Exxon effectively, acquired by Savannah in Totco, and created a new Chadian petroleum company. Now, they obviously couldn't nationalize the assets in COTCO because COTCO is a Camerooni company. So the nationalization of Exxon's shares in the Chadian company took place, and that was a parliamentary decision. It's a complication in the puzzle because acquisition of a majority stake in both Totco and COTCO by the Chadians was actually done quite lawfully, quite contractually. Correct. And that gave them control. The dispute then arose because the Chadians then tried to exercise their majority control of COTCO by changing the board and appointing their own directors. And so you had Savannah directors who the Chadians had said were illegally appointed, or unlawfully appointed rather, and then the Chadians appointing their own directors, and that led to the emergency arbitration in Paris before the international ICC arbitration process. So the Chadians also argued that the right to hold shares in COTCO had lapsed because the Savannah entity was no longer a member of the consortium. So these are all the legal issues which have not yet been decided on the merits. But the emergency arbitration to the ICC related to these board changes at COTCO, who controlled the bank accounts of COTCO.
Yeah.
And that decision was made in May 2024, which effectively suspended certain board resolutions, maintained the status quo, and said the merits still need to be decided. In the background, of course, you had this diplomatic clash between Cameroon and Chad.
Yeah.
Because a further complication was that the Cameroonians had signed a deal with Savannah to acquire 10% of COTCO. So it's quite complicated. There's a lot of issues here. But it seems to me that the heart of the matter is this it's a contractual issue. The nationalization, one can debate whether it was necessary, because certainly the ICC emergency arbitration made it quite clear that they said they didn't make a decision, but they think that it's permissible to question the validity of the acquisition based on the failure to get prior ministerial approval, and also deal properly with the preemptive rights issue. Because that seems to me to be a strong case on paper. The nationalization, I haven't been able to really understand where that fits in, except they seem to say that if by not being a member of the consortium, that would affect the ability of Savannah to have shares in COTCO. There isn't, but I couldn't, it's not clear from the arbitration decision exactly how strong or weak that argument is. I can't really make an informed decision. But the puzzle here is, did they really need to nationalize the assets, the shares in Totco? Because they seem to have a very good case on the contract.
Yes, and what additional...
Sorry, but long introduction to the facts. But,
yeah, thank you very much, Pieter. Which additional benefits did the Chadian government get from the nationalization process?
I think, that it seems to me that they thought it was within their control, but the problem is the unintended consequences of any nationalization.
Yeah.
You nationalize one company's assets. And I think if you look at it, seems to be a parliamentary decision, which is effectively a political decision.
Correct.
It's not as if there was an act, that they acted within a statute which regulated, have an expropriation act or something like that, which is where there's this legal process, due process, where there's maybe court oversight, because the unintended consequence of any nationalization, particularly something which seems to have been quite knee-jerk to a particular case, it sends a message to the investment community, both local business and foreign business, that there's a risk here. How do you manage that risk? Who's next? If it was Savannah or ExxonMobil now, who's next? It puts the country on the red list.
Yes.
Red flag.
That's right.
So, what investors need are, firstly, I think, a strong rule of law and certainty of the investment. And, that I think is the unintended consequence, because Chad has significant oil deposits, but if you can't get them, Chadian government doesn't have the resources to develop them, so they need to get private sector involvement. And how do you incentivize them? It's something that I think, I think Sydney and Zambia is one of the cases where there was a nationalization of copper mining assets, which eventually led to a privatization. So it's a question really of, I think that's the risk of this nationalization in Chad. It's put them on the red list.
Yeah. And it is also interesting because Savannah was represented by good lawyers. I actually reached out to them months ago with this particular panel in mind. There was no response, but it appeared from the outside that it's UK lawyers, it's reputable lawyers. So it's quite interesting that something that like this would happen, that one would go into this type of contractual problem.
The agreement drafted on the basis they were subject to these conditions. It seems to me the parties took a view and said, well, we're completing. It's difficult to speculate, but ExxonMobil got their $409 million. And it's interesting, ExxonMobil is not referred to, so one has to assume that Savannah's not holding them responsible or trying to cancel the deal.
Exactly.
ExxonMobil seems to be, they have their money. And so I think from what one can read, it seems that if the conditions were not fulfilled, Savannah's not trying to get out of the deal. In fact, they're trying to enforce it. But the merits of the case will be debated in the ICC arbitration unless there's a settlement. As a commercial lawyer, say both parties should explore settlement on some sort of reasonable basis, if possible.
Yes. And Pieter, do you know when that arbitration hearing will take place?
It's unfortunately not clear from the public record.
Okay, right.
That's one thing about arbitration. It's basically not as much in the public domain as a court case.
Yes. Thank you very much, Pieter, for that intro. Isaac, can you provide us with your views in relation to the nationalization of assets from a regulatory perspective? Any comments on Pieter's explanation of that deal that went wrong?
Thanks, Odie, and I think we actually got a very good lecture on law and contracts and applications as well. When I read through the few links that you provided on the materials that we'll look at in preparation for this call, myself, I just thought I would focus more on competition regulation part of it, and which I agree with Pieter, that when I was reading through it, I saw, okay, but this sounds more of a disagreement after the transaction. But I also noticed some issues, even in respect of the major application process, the notification, the stakeholder consultation process, and equally the examination itself. My understanding is that there were issues that could have been either identified during the process, which could have highlighted these red flags to the extent that maybe a solution would have been found earlier than it went until the end. Because what we appreciate is that competition regulation is equally part of all other government processes, in particular to do with economic development. On investment, competition plays a role there. I don't think there's any investor who would want to invest an economy and don't want really to appreciate what competition regulations apply in that country. Of course, there are issues that I'm not sure of. I didn't have time really to check on whether the Cameroonian side has a competition regulator or not, and whether the Chad side also have a competition regulator or not. But my comments will just go on assumption if it was there that this could have happened, and or if it's there on the Chad side, this could have happened. What I tend to realize was that when the transaction, particularly on the notification side, we realized that they notified and applied for notification to the regional competition regulator, which my understanding is that as an investor and as you apply for notification, there are provisions within the competition regulations which say that you need to provide as much information as possible. We should be as transparent as possible and equally provide any information that might have an effect on the transaction to the extent of showing where else you have notified, what are the likely effect, who is involved, and all those things. So in that context, there is a situation where I understand Savannah did sell some 10%, which Peter was referring to the Cameroonian government, which my understanding is that on the notification part of it, that information was supposed to have been provided to the competition authority so that when they examine the transaction and when you consult stakeholders, such kind of information will be made available. And the other thing is on the consultation process, our understanding is that from a competition regulator perspective, you look at who is significantly involved in this transaction, and obviously you go around to check on the customers, on the competitors, and all that. So there was no way that this transaction would have gone through without consulting the Chad government as a part to the transaction, which by so doing, it means that the government would have raised these issues well before before the transaction was approved. That's the view we have insofar as notification and also consultation. The second observation was that if there were competition authorities, I don't know if they are there, but if they were there in Chad and or in Cameroon, those issues could have been raised because normally even from our COMESA experience, when we engage national competition authorities, those are the things that they'll be looking at. Who is going to be affected by this transaction? Get their views, and then in that process, you try to resolve some of these problems that can then arise later on. I heard Peter saying that the transaction was approved with conditions, and it is some of those things that then will be looked at. I see Peter is raising his hand. Maybe you want to intervene like now?
I think that's a very interesting, the issue is the acquisition by Savannah of shares in Totka and Kotka. The Savannah ExxonMobil decision wasn't actually notified. And I think it's because the shareholding was about 40%, which is obviously a minority stake. But the question in South Africa, we'd say, well, does that amount to control? Because it seems that transaction didn't go to CMAC and certainly didn't seem to require a local Chadian Camerooni merger filing. So it's interesting because it does raise the broader question of when should the acquisition of a significant minority shareholding require notification. But it's just that I think is just as Isaac was talking about it, I just thought that's an interesting because it raises that bigger issue of how to deal with minority shareholdings.
Yeah, that's a very good point. If I can also just quickly say something, I understand that ECOWAS, they are also not using the change of control test, but a more lenient test, materially influencing, the material influence test. So that's a very good point, and that's something, well, it's perhaps something to flag. Sorry, Isaac, go ahead.
No, it's okay. Yeah, that makes the panel more interesting because which I agree with the observation by Peter, because it also depends on what is provided in the regulations in those countries and or in the region. Because if I try to reflect it from a COMESA perspective, obviously on the notification form itself, there is also need for parties to indicate what are their plans, what are their motives, or what do they intend to do after the transaction and all those things, because that will also be part of the examination process.
Yeah.
Remember, measures are futuristic, so you would want to see what are the likely happenings after this transaction. So it is such critical information which needs to be highlighted. We intend to have, okay, we are acquiring 40%, but maybe in the near future we are considering to increase or whatever you intend to do. That will then give the regulator a clear picture of what they have to look up to as they examine the transaction. I'm sorry, I will focus more on competition regulation because that's
absolutely.
what I know. That's what I know most. So
of course,
yeah.
this is why we want you here.
Yeah. But I would also want to emphasize the significance of an effective regional competition regulator, because not saying that CEMAC was not effective, no, but just to highlight that an effective major examination process and procedure, I think would also have averted maybe or reduce the extent to which the problem we're looking at somewhat, because I understand if I'm to follow the system that COMESA applies, I think some of the issues would have been flagged well before they went out of hand. So maybe it is critical that in these circumstances, where issues involve cross-border measures, an effective competition regulator can be very, very helpful as well.
That's right.
That is one observation. But to also go back and look at what Peter was highlighting, expropriation of assets, like everywhere else, and in this global world, it's not looked at in the very positive direction, whatever the reasoning could be. It also brings in the high risk issues. It makes the economic environment considered very risky, to the extent that it might not even attract the best of capital. The capital that will be going there will be very expensive. So in such circumstances, even if government believes that they've been misled, maybe there could have been better ways. We know it is national interest. Governments will have national interest. So where they feel that we have been misled, and now they will be saying we want to protect our national interests, and as such, they end up undertaking such. But it is important to follow due process, being transparent, and also a sense of proportionality can help in this process. So in concluding, I would think that if we look at the case under consideration, we would think that it is important for investors to be as transparent and to be as honest as possible and provide all the requisite information to the regulators who will be making decisions, because that will be very helpful in informing the decisions and even the process itself. Because I understand if the information was provided for to the extent that the governments are very much involved and they are very much interested in these issues, it was necessary to involve them as stakeholders. Say, okay, we are looking at this transaction. What is your view as a government? We understand you have a stake in this. What is your take on this? That was going to be very, very helpful.
Yeah.
But also, finally, in response to such kind of, there is need not to undermine investor confidence, and also to avoid international legal disputes. And even I saw there were some strained diplomatic relations in this issue. So it is something that there is need really to take care of such as we approach these investment proposals. Thanks.
Thank you very much, Isaac. I'm just a little bit curious. Would there be a forum where COMESA and CEMAC would meet, for example, to discuss something like this, or even the other big ones? I know every now and then the the CMAX of the world and COMESA, ECOWAS, WAEMU, you come together and you have some discussions. Do you think that there would be some room to discuss this particular thing or ask more questions? How did it happen? And those types of things?
Yes, sure. Odie, like your observation is very correct that COMESA actually championed the working together of regional competition authorities in the understanding that it is necessary, and particularly as we build up towards the African Free Trade Area Competition Authority, it was found that it's very necessary really to build up that by first integrating and or bringing together the regional competition authorities as an important stakeholder. You know, in this FCFTA process, regional economic groupings are very critical given the structure and the nature of the African continent. It is important to have regional competition authorities as well. So in that process, there are a series of meetings that have been arranged, and we're also moving closer towards having a cooperation agreement among the regional competition authorities. And as it stands, when we meet annually, it started in 2023. So we will be going for the third meeting, now being hosted by EAC. But in our discussions during those meetings, it goes through all these kind of issues, because then we'll be updating each other on the development that will be happening in each and every of the regulators. And among other issues that will be discussed are these major examination processes, engagement, investigations into anti-competitive business practices, advocacy, issues about research and all that. So in all this, it is a process where we're trying to make sure that there's harmonization. As we, like I said, as we draw towards the FCFTA, there's need really to have such much harmonization among the regional economic groupings. And also it will help in circumstances like this Chad and Cameroon issue we are looking at. Thanks.
Thank you very much, Isaac. Yes, we invited Ms. Nyama Lawrence, who is the director of the COMESA Commission, to be with us today. And unfortunately, yesterday she said that she has to go out on an important mission, so she profusely apologized for not being here. Otherwise, she would have been on this panel. In the interest of time, I'm going to move to the next question, which pertains to the amendment to the Zambia Competition and Consumer Protection Act. And that was towards the end of 2023, there was an amendment that stated that competition approval must be sought in instances where a company wishes to relocate its core assets outside of Zambia. And this means basically that a company must not only obtain exchange control approvals, but also competition approvals in order to exit the market. And to my knowledge, this is quite a novel amendment to competition laws in Africa. Sydney, can you take us through that? What was the rationale for that, and was it subject to public consultation? If you can provide a little bit of background, and if you also want to comment on the issue of Chad and CMAC, you're of course more than welcome. Thank you.
Well, thank you, Odie. Very interesting conversation. Just like Peter and Isaac have observed, usually when there's an expropriation, I think it puts the country into a spotlight. And we've had experiences in Zambia where there's been expropriation of a telecom company in the past. It had an adverse effect on the inflow of foreign direct investment because there was a feeling that the government then was not investor friendly. So it does have repercussions in the doing of business, investments. A few years ago, we had a similar issue, which was an indirect way of expropriation involving a mining company. And now this was taken as a liquidation, when in fact, I think it was the state then trying to avoid consequences of expropriation, such as compensation, adequate compensation, to the owners of the business. So I just thought I'd just comment on that. It really has, because it puts you on the spotlight, and there's no investor who would want to invest in a country where the laws either they're not respected or they're not sure, or in terms of dispute resolution and all of those things. So I'm happy in the Chad instance, there was an effective dispute resolution, which was the ICC arbitration. Because for us, most of the investors that we advise, we obviously want an arbitration to be done out country, for the simple reason we want to make sure that the process is fair, transparent, and there's no form of interference. So mostly it will be an ICC or an exit type of arbitration. Now, coming to...
That's very interesting. Sorry, Sydney, I'm just quickly going to add to that. I have a friend who's working at one of the large paper companies, and he actually said about 2-3 years ago that they've started to exit Africa because of this risk. Every now and then they don't have their asset or their plant anymore because it has been taken. So it's a serious issue, and one of the reasons we thought of making people in Africa aware of that. Thanks, Sydney.
Now moving to the new amendment. So we have this novel amendment to the Zambia Competition and Consumer Protection Act. So on 26th of December 2023, the government enacted through Parliament Act number 21 of 2023, which effectively made wholesome amendments to the Competition and Consumer Protection Act. Now, in general, what that amendment has done, it has sort of increased the enforcement powers of the Competition Commission, because in terms of their powers in regulation, there were certain provisions that, for instance, did not have the administrative fines as a penalty. And there were also some provisions that only provided for administrative penalties. But what happened with the 2023 amendment is that most provisions now have both the administrative penalty and also a criminal sanction. So this has, sort of enhanced the enforcement powers of the Competition Commission in Zambia. So what that means is, because of the 2023 amendments, most businesses must have very high compliance levels to avert, sanctions. Because we've seen even generic provisions that prohibit anti-competitive agreements or conduct. Now, the Commission has administrative penalty powers to impose on the parties. In the past, it would have been maybe directives or orders or any other, but not really a financial sanction. So that has been the generic effect of these new amendments. Now, in terms of the specific, which is the issue of obtaining approval if you are relocating core assets. Now, if you look at the amendment, it actually has defined what core assets are. So according to Section 2, core assets means essential assets, includes valuable property, important property without which a business cannot carry on any of its operations. So that's a definition. Now, in terms of the amendment was done to Section 23 by the inclusion of Section 23A and Section 23B. So Section 23A talks about or creates the obligation by a business that wants to relocate core assets out of jurisdiction to obtain approval from the Competition and Consumer Protection Commission. Then Section 23B talks about the process, the procedure on how you go about that. Now, of course, as an antitrust, practitioner, we didn't take the new amendment very well for two reasons. The reason was, the first one was because we felt that it's outside the scope of competition law to restrict the movement of assets belonging to a business. And we did participate in the debate at the stakeholders workshop. We put quite a lot of lengthy submissions in opposing this particular amendment. So the first one was, of course, we were arguing to say that it's outside the scope of competition. That was number one. Then also the second one was the potential constitutional breach by this new amendment, because under Article 16 of the Zambian Constitution, you are entitled to your right to property. And there's only one instance in which your property can be taken away from you. And this is where the government compulsorily acquire your property. They give a reason, and you are paid adequate compensation. So potentially in future, we see a problem with challenging this particular provision. And I'll give you an example why. I'll give you a scenario. So if an investor invests it's a greenfield project, and they import into the country machinery that is core to running their business. Because remember, they've not found this machinery. It's a greenfield project. They have brought this machinery using their own resources into the country, and they use this. And now when they decide to exit, what you are telling them is that they must seek permission to take away their property.
Yeah.
Now, the question is, what happens if the Competition Commission refuses or does not grant the approval for whatever reason? So that is a potential constitutional breach in my view. And also it does not speak to, it goes beyond competition regulation, because it is possible that they can indefinitely give a rejection. Then what happens to the investor, or who, for whatever reason, they decide to relocate or close shop in Zambia, and they want to go to another jurisdiction. So in terms of our opposition, there was a process, a stakeholders workshop. That time it was chaired by the Minister of Justice. So we were made to give submissions, and we used that platform for us to sort of challenge or give our views. We were assured that our views would be taken into consideration at the time. Then the amendment in 2023 came. Then we found that it was in its original form, despite most of the submissions that we had given against this new provision. Now, one of the issues, of course, that we rose, we went back historically. Now, if you understand the history of Zambia, you will notice that our Competition Commission was set up in 1994. Now, this coincided with the structural changes in the economy, where we were moving from the old socialist-styled economy to a capitalist economy, where there's free market economy. And that's the reason that 3 years later, in 1994, from 1991, the government decided to enact the first competition legislation in Zambia, which was the Competition and Fair Trading Act of 1994, which set up the Competition Commission. Now, under the old laws, because there was a lot of privatization at that time from state-owned entities, and we had a lot of investors coming in. So there was a law which restricted, the taking away of core assets out of the country. Now, the reason was that they wanted to stop what is called asset stripping, because what was happening was that some investors would buy a business at a relatively fair or cheaper price. Then what they would do, the focus was not on running the business forward. So the focus was on the equipment or the assets that business had. So what they would do is the transaction would go through, then a year later, they would cease operations. Then they would take away the assets, the plants, and relocate them in another country and continue doing the business. So at that time, there was a law which restricted that. So our argument when this amendment was proposed was saying these are two different circumstances, because this had been there before. So what we were interested in understanding from the competition side and the government side was, what were the policy considerations? Because we needed to understand what were the policy considerations that enactment could be brought back. So our argument, of course, I've said, was twofold. We thought it was potentially unconstitutional. Then secondly, we thought that it was outside the scope of competition law for you us to put another layer of restricting the relocation of core assets. So this is the background and some of the thoughts or reasons why we oppose this legislation.
That's very interesting, Sydney, especially connecting that with the previous legislation regarding the stripping of the assets. That's very interesting that it had that same flavor. Yeah, thank you very much for that. And nothing has changed. And do you foresee that anything may change? I mean, we've just been through another amendment and everything is alive and well. It doesn't appear as if there are any changes. What is the way forward with this clause or provision?
Yeah, so as it stands now, Odie, the provision hasn't yet been tested.
Okay, right.
We're not aware of anyone who's made an application at the Competition Commission to relocate core assets, and an application has been made under the Competition Act for approval of this. The process of applying is the same, like when you apply for a major, you use the same form. I think the documentation required are similar. So it's basically the same process, but you obviously indicate in Form 1 that it's relocation of these core assets out of Zambia. So it hasn't been tested yet, but what I foresee for the future is that there will be at some point a challenge to this provision. Yeah. Because, in my view, I think it infringes on the right to property. Because it's your property, you can do whatever you want to do with it, and unless there is a justification, and the Constitution does provide the instances in which property you can be deprived of property, and if it's compulsory acquisition. Now the problem is where the Competition Commission, for instance, rejects your application indefinitely, then you are stuck. You can't move your property. So what would be your recourse to that? So I foresee that there will be a challenge, but it's a relatively new amendment. There hasn't been anything yet. Because the business environment in Zambia at the moment is very, very good. We've had a lot of FDI inflows into the country because the government is investor friendly. I think most of the major disputes that were there in the past, most of them have been resolved. So it's a business-friendly government, and we don't foresee that as of now there will be any challenge. Maybe in future, because we've had different governments before, and where we're coming from, it was not investor-friendly. We were in arbitration, I think, for a very long time. ICSID, ICC arbitration, trying to protect investors. But at the moment, there are not so many state investor disputes. So maybe for now, I think it will be very difficult for it to be tested in the near future. Maybe, of course, there's a possibility, but it's something that I think there will be a showdown, for a lack of a better word, at some point to just try and test this provision.
Thank you, Sydney. Thanks so much. Pieter, any views from your side on this development in Zambia?
When I read the provision, I agree with Sydney. It's not traditional competition law, and I tried to think, how would a competition authority apply it? What test would they apply? And I suppose if you can attribute some sort of market share to those core assets that are leaving the national market, then that means that the other participants in that market, their shares are increasing. I mean, maybe that would be something that they would look at. Yeah. But in the context of, Zambia is part of COMESA, in the context of the African Continental Free Trade Area, that does raise the question whether this provision actually makes sense, in the sense that there's a regional market. I suppose if you're relocating your assets to another continent, but why would they do that? It puzzled me, because I wondered what test and what harm is the provision designed to combat. because as Sydney rightly says, it's private property. No third party is acquiring it. And I suppose, if you read the definition, it says essential assets essential assets, but includes important or valuable property without which a company is unable to carry on its normal operations. I mean, the test about normal operations, I read that as the company's closing down, because if it's essential to conducting normal operations, it means you're closing down your factory, but it says it includes. So essential assets could be maybe intellectual property, or intangible property.
Good point.
Skilled services. I mean, the services business industry is booming. So how does it apply to core assets of the services business? It's a good brain teaser. So thank you for it certainly led to a lot of questions.
Yeah.
Yes.
I'd really like to hear Isaac's view as a regulator. It's always nice to have a balanced view. So Isaac, I don't know what you think, because we had a long debate, because assets can be in different forms, like essential assets. Some companies, it may be a software. That's what they use to run a business. So how do you capture that? Sometimes it may not even be in country. So there's quite a lot of questions around that provision. But it would be good to hear what a seasoned regulator would his opinion is.
Yeah, let me tell you what happened when I remember here I'm representing the CEO. He was the one who was supposed to come, but because of the amendment to the regulations that is happening, he's there in Lusaka actually. So they are at the secretariat, where he's representing the commission in respect of the amendments to our own regulations. At least we don't have this one for exit of assets from the market. When I heard about the discussion, I had to go back. So I wanted to just have an understanding of what is this. And so I had to call my colleagues there at CCP, say, okay, tell me more about this thing, because it seems very new, and I've not heard about such kind of legislation or kind of a provision. When I tried to appreciate their point of view, actually, it pointed more to what Sydney have highlighted about asset stripping. I think your experience as a country, maybe to some extent, or in someone's mind somewhere, still have the thinking that yes, today it can be very investor friendly. It might not be the case at some point, and then maybe to protect national interests and all those kind of things, then there is need to have that kind of a legislation. But when we want to look at it purely from a competition perspective, obviously it depends on the structure of the market, and more critically on the definition of essential asset, like you said. I've not said much, but from the definition you gave us, Sydney, what it points to, yes, there could be possibility of controversies on defining that. And in some instances, it might also not mean anything. Like you're saying, say, if the asset is a software, what do you want to hold on to at a country level? So I think then maybe also the CCPC, as they try to enforce the law, there is need really for them to develop very, very detailed guidelines in respect of how they will be assessing the individual aspects of the transactions. To the extent that it becomes very clear for anyone who would want to do or to allow their assets to go, it will have to be very clear whether the law applies to them or not. So I think what will be critical, you lawyers, you tell us that there's no, you say good or bad or law, whatever. I can't remember the terms that you use. You say all laws, it depends on how they are used and what determinations will be done by the courts in that respect. So from a purely competition perspective, I think the understanding will be on whether that movement of assets from Zambia will not create a situation where we will end up having a changed market structure, which can have effect on competition. So you understand that there could be instances where we have two players in a market. I'm just using a literal example. I don't know really what would be the circumstances. There could be two players in the market and one is leaving. So it would be from a competition perspective to say, okay, instead of the assets leaving, why can't you just sell them internally and then we remain at least with another competitor in that given sector? That's the context in which I would look at it and say possibly that's what the policymaker had in mind. You say, okay, fair and fair, you believe in the market, and as you were highlighting issues of constitutionality, I was thinking, what if they make a decision to say you sell, not just leave, you sell to whoever is willing to buy them. But maybe Sydney, where the problem will arise is when then you want to sell and no one is willing to pay the value that you have determined on the asset. Maybe that's when could be an issue really. But if you are asked to say, okay, you can't go with the assets, can you dispose them off? I think in that perspective, at least you get a bit of your value, but also the process of competition has been maintained in that given market. That's the context in which my wildest thinking will be, but the call will be that CCPC really needs to come up with a very, very detailed guideline that can then remove all uncertainties, all unpredictability, and even the risk. Because, like you were saying, that there is a risk to bring in fears to investors. Whenever someone is considering getting into a market, they also assess the extent to which they can easily exit that market.
Exactly.
So it is important that there is a clear, transparent way through which that cannot happen. And also, my other thinking is, I think there is need to have a first categorization of those assets, whereby there could be those other small assets. Please let them just go if they can easily be replaced. Then there are those medium, maybe that could be have issues that then may need to have the competition authorities. And then maybe there are those very big and very important assets that really can have a big effect on the market. So maybe they might need to come up with thresholds also on which assets and at what level of value that needs to be considered. That was my view. And maybe one issue about regional competition regulation. Yes, true. It is very important. I think as a consideration, it's one thing that they also need to put in the legislation to say if the destination of the assets also needs to be assessed. Where are they going? If it's within the region, then possibilities that the consideration will not be as high as if they are going international.
Wow.
That would be my submission. Thanks, colleagues.
Thank you, Isaac. Very valuable points. And I understand, if I remember correctly, that the rationale for this amendment was that the fear of too much concentration upon the leaving. So I fully agree with you. I think, Isaac, that has been quite important. And the issue is also that when you raise barriers to exit, you automatically raise barriers to entry. So that's also a conundrum there. We are in the last 10 minutes of our discussion. Can I quickly ask each of you to provide a quick, crisp summary of your thoughts on the expropriation issue? What is the main lesson there? And then also in relation to the Zambian amendment. Thank you. Pieter, can we start with you?
I'm just going to switch off my video. There you go. I think on the expropriation issue, I think one has to, the lessons from the Chad case is, what do we mean by expropriation? I think expropriation of assets, shares assets, like the Chadian parliament did, that's a clear example. But where, for example, a mining right is revoked. I mean, in Tanzania, the mining right of Montero, a company, was revoked, and they're claiming compensation. The issue is, if there's a breach of a mining right or some other concession or license, then logically the consequences, there's a risk of that it will be cancelled or revoked. If it is revoked without good cause, then you almost think that's getting into the expropriation scenario where you give somebody a right and you take it away. As you know, in South Africa, we've got an expropriation act which which is actually an act of parliament, which sets out a process with court oversight, which has been highly controversial. The President of the United States has called us out on it. But it does, the key thing, I think, with all expropriation issues, if there's an expropriation, is there good cause and is there compensation? And is the compensation fair? In South Africa, we've got the so-called just and equitable test, not fair market value necessarily, or willing buyer, willing seller. We've got the provision which says that just and equitable could be zero, which is the controversial bit. But I think this whole issue of expropriation, it feeds into the investment environment.
Oh.
And, business needs certainty, investors need certainty, particularly if we want them to invest in our countries. On the Zambian issue, just briefly, I think, again, the key thing for me is, it's a relocation. I mean, the business has decided we are going to relocate this asset. We don't want to sell it. We actually want to keep it. We need it. We've got a plant, say, in Zimbabwe or Malawi, a neighboring country, and we need it. We want to send it there. Now, by saying that you need approval to do that raises all sorts of commercial issues. And I mean, the key thing for competition and any regulation in Africa or outside Africa is, where do you draw the line so that it makes sense? And it must be clear, firstly, as well. But then, does it make business? Does it make commercial sense? Does it serve the developmental and social goals of the country? I think that must be the test for all regulation. Intention is not good enough. I always say it might have good intentions with the law, but what are the outcomes of that law? And that's really the test of its success. Thank you.
Right, Sydney, what are your final thoughts? Thank you, Pieter.
I think on expropriation, I think I share the views by Pieter, but for mostly developing economies, I think it's important to avoid expropriation unless there's really, really a valid reason. And where there's a valid reason, you need to follow the process under the law, provide adequate compensation, because in our telecoms case, there wasn't initially any compensation that had been provided. Then we had to go to court for us to get an order. Fortunately, it was settled by consent. Now, it has a negative impact, I think, on the image of the country in terms of business. And also, there's a correlation with reduced FDI coming into the country. So my final thoughts is to avoid it if we can. And if we can't avoid it, a transparent process which is lawful should be followed. Because also it goes to investor confidence if you do not follow the legal process. Then on the provision on core assets, from the onset, we were against it. I still maintain it, because up to now, I'm still struggling to understand, the policy consideration. There can be many. I think Isaac alluded to maybe you're avoiding concentration in one particular, relevant market. But the way it stands, we did actually inquire to find out, what is the policy behind this new provision. So I think that it should be revisited. If it can be revisited, at least refined. I think Isaac mentioned, adequate guidelines for us to really know exactly what we are doing. Then also the number one issue in most developing economies, of course, at the regional level and the national level, is to facilitate business. And most investors, want, a clear, transparent process without unnecessary hurdles. Because I think some of the issues that should have been looked at is certain businesses are transitionary. They're not there for forever. They can be there for 10 years. For instance, if it's a mining company, maybe the life of the mine is 15 years, and they have operations in other jurisdictions where they would want to move their core assets. So it may also have an impact or a negative impact on attracting, especially transitional businesses that only operate for a certain number of years. So my last thought is, I think it's something that should be looked at and revisited.
Thanks. Thank you, Odie. Thank you very much, Sydney, for those closing remarks. Isaac, what are your final thoughts?
Yes, sure. Thanks, Odie, and thanks, colleagues, for those comprehensive final remarks. My thinking will go both to instances of the Chad Cameroon case and then the Zambia issue, because if we're looking at the risks, they're almost the same.
Exactly. Yeah.
And from a purely competition perspective, I would say that our CEO always said this, that we are not therefore to frustrate business as competition regulators. We therefore to facilitate business. And in that facilitation process, obviously every of the stakeholders plays a very critical role. And in this instance, I will point out to issues around investment. So to the investors, if I was to talk to them in respect of the Chad case, and equally indirectly on the issue of asset movement, it is important that investors they have access to predictable, very transparent processes, so that when one comes, they want to undertake a major transaction, like in the case of the chat, they know I have to provide this kind of information and I have to provide this kind of detail, and then this is going to be the decision and all that. That is very critical. That will allow us to create investor-friendly environments in our so much investment deprived economies. So it is very important to have that. But also to the investors themselves, when they look at our markets, they also need to be very transparent and honest as they approach us.
Yeah.
Equally, when they approach the government and when they approach the regulators, that will also provide, it will clear out a lot of unnecessary contractual issues like the case we have seen there. So it is important. Oh, and equally to the governments, our governments, they need to be aware that investment is very important, and creating an investor-friendly environment is also very good. An environment needs to be predictable, and that will help. And to us, competition regulators, advocacy is also very important. Harmonizing our regulations is also important, because I see that in an instance like the Chad Cameroon case, if the regulations were harmonized, it was going to be very easy to predict what is required in terms of consulting stakeholders, in terms of gathering information from the investors and all that. Then it would have helped to avoid this anomaly we ended up with. So, and also to the competition authorities, it is critical to capacitate ourselves and capacitate our staff, because I see in the examination of that measure, if there was that third eye which would pick some of the challenges, it was going to resolve some of the problems before they become on board. And then finally, on the Zambia case, my issues, I'll just echo the same issues I've highlighted, that there is need really to develop very detailed guidelines that will give predictability, transparency insofar as the enforcement of that regulation is concerned, and also it is the responsibility of the CCPC to ensure that they remove barriers to entry into any economy, so that we don't fight for what we want to live. We should actually promote, more entry into the market rather than forcing people to remain in the market. That would be my final say. Colleagues, thank you for this time.
Thank
Thanks.
you. Thank you so much, Isaac. And if I think, Pieter, if I think back to what you said, that investors should also not underestimate the intelligence of African governments and African regulators, not to take views that are directly in conflict with whatever had been agreed. So it's a well-resourced continent. I think this is also maybe something that you also alluded to, Isaac, and I just wanted to reiterate that. It's been a massive pleasure to engage with you on these two very tricky issues, and I really appreciate you doing all the pre-reading, all the cases. Sydney and Isaac and Pieter, thank you very much for your wonderful contributions, and let's keep the discussion open. It would be great to stay in contact with you on issues of state control over private assets.